24. At a request made on behalf of the respondent, who submit statement of objections will be filed. Relist the matter on 24.
Much obliged.
Number 6, number 7. Number 7.
Yes, who appears for the respondent? Official liquidator. Yes.
File is given to Madam Revati. My lord, that's the first hearing. My lord, he says that there is a previous order, my lord, which applies to this case also.
Serial number 7, my lord?
7.
Yes.
In this, my lord, there is a non-compliance of his objections from the other side, my lord.
Applicant is permitted to serve copies of the application on the respondent. Relist the matter on 24.
Obliged, my lord.
The appear for the applicant in CA number 467 of 21, my lord. Last date of hearing, learned counsel, my lord, Mr. Saji P. John, had taken time to file objections.
May I request for another 2 weeks, my lord? I'll file objections because it's an old matter, my lord. It's NGF relating to NGF. My lord, I am requesting 2 weeks time for filing objection.
At request of the counsel Saji P. John, list the matter after 2 weeks.
Please, my lord.
Appearing on behalf of the petitioners in this matter, Your Honors.
Yes.
Your Honors, on the last occasion, the respondents were directed to file an affidavit with list of assets. It has not been yet filed.
Yes. You appear for?
It's an application for restructuring and applications pending by the company which is ordered.
NCLT.
No, you know, the CA is pending. On the matters, permission for restructuring.
Restructuring we can do here now. Who appears for the respondent?
Raghu? Raghu?
No representation on behalf of the respondent. It made clear that if the respondent who has filed a CA 40 of 21, isn't it? Remains absent. Further orders will be passed. Now simply dragging on the proceedings. Let us see. Relist the matter on 24 finally. 24.
Much obliged.
If they are not interested, we'll dismiss it. That's all. Otherwise, let them move the NCLT under the IBC code for restructuring.
Mahabaleshwar?
I appeal for the petitioner in this matter, my lords.
I appeal for the respondents, my lords.
Yes.
My lords, as submitted on the last date of hearing, my lords, the DD was taken to the office of the petitioner company's Bangalore office, my lords. In fact, my client has also met with my learned friend yesterday in his office. My lords,
Yes.
the problem is the petitioner company is insisting that the DD be drawn from the respondent company's name. Now, my lords, the problem is the respondent company's accounts are all freezed. Though we are telling them to accept the DD, they are hesitant and insisting that they want the DD to be drawn from the name of the respondent company itself. So,
Now
my lords,
we'll
we will
make
have
it,
to.
Now,
Yes,
we will say that the amount is being paid on behalf of the company. We'll clarify.
Please,
in
my
the-
lords.
Yes, what do you
That
say?
can be done, my
petition-
lords.
Please, my lord, that can be done, my lord.
The respondent submits that there are certain difficulties in making payment in the name of the respondent company.
Please, my lords.
And amount that is paid by, now who's making the payment?
My lords, the payment is being made. The DD is drawn by one Mr. Valli, a well-wisher of the respondent company.
And payment will be made on behalf of the respondent company by
One Mr. Valli, VALLI.
Mr. Valli. In light of the submission made by the counsel for the respondent, the payment, if any, made by Mr. Valli will be treated to be payment made on behalf of the respondent company.
Please, my lords.
Please, my lord.
Now, next, when do you want it?
My lords, now my learned friend should be submitting this. My client has met with my learned friend yesterday in his office, and they have come to the agreement conclusion that, my lords, the next payment will be made from the month of April first week, my lords. And the petitioner company also, they have not shown any disregard towards that. They have accepted our contention.
Mr.
Please, my lord, the next settlement would be on the April 1st week, my lord. I would agree with
Now, so now how much you are going to pay now? You have
Now,
paid
my
or
lords,
to,
this GD is for a sum of rupees 5 lakhs, my lords. In the month of April first week, a sum of rupees 10 lakhs will be paid.
the counsel for the respondent submits that a demand draft of rupees 5 lakhs would be handed over to the petitioner company shortly. Said submission is recorded. It is further submitted that further payments will be made in the first week of April. List the matter in the week commencing from 11th of April.
Please, my lords.
Obliged, my lords.
Obliged, my lords.
Number 11, VN Prakash.
Yes.
Hari Prasad.
I am for the appellant by respondent by way in this file.
They have not paid the balance amount. They have to pay 2,25,000.
For the respondent by me in this case, my lord.
Yes.
I
Remaining
pay some
amount.
more. I need some more time, my lord, because he's suffering from COVID. He could not arrange the amount, my lord.
So when do you want? When do you want it? Take a date and by then you make that payment.
Once, 4 weeks time may be granted, my lord.
Is the matter finally in the week commencing from 7th of March. Let us
Please, my lord. Please, my lord.
Number 12.
I'm appealing for the official liquidator, my lord.
I appear for respondent number 2, my lord. I have filed the objections on 25th January. It is on record, my lord. My lord, in my objection statement at ink page number 19, I have at ink page number 19 of my objection statement, I have annexed R1 document, which is the original side appeal, which is pending before the Honorable Division Bench. Therefore, the applicant, without exhausting that remedy, cannot file this application at this stage. And the second document is they have been contending that there is a partition suit. That document also I have annexed, my lord. The order dated 21st December 2021 has rejected the contention of the applicant before the trial court, and the partition suit has been rejected. The plaint has been rejected, my lord. Therefore, on the contentions of the applications and the above points made, nothing remains, and the application may be dismissed with cause in my favor, my lord.
My lords, I appeal.
Yes.
My lords, I appeal for the applicant in 330 of 21, my lords.
Yes.
The pleadings are complained. Complaint to the court may be taken up today, my lords. My lords, if I make few submissions, my lords, on the application.
Yes.
My lords, I would draw your attention to Annexure A of my application at 12, my lords. My lords, this is nothing but the winding up order passed by this honorable court. In fact, it is passed by your honors, my lords. My lords, acting on this order, the official liquidator has taken charge of the assets of the company. And on doing so, he's taken the charge of the assets which do not belong to the company, my lords. He's taken, as of today, on 8th November 2021, he's taken charge of the symbolic possession of the residential property, that is the residence of the applicant, my lord. And on doing so, he stuck a notice on the doors that he's taken symbolic possession and no one can interfere with the property, my lords. My only request is, the applicant here is not of the liquidation. My only grievance is that no be put elsewhere and I may be permitted to live in the house, my lords. The applicant, none other than the daughter of the respondent number 1 company's the daughter of the managing director of the respondent number 1 company. The parents have abandoned her, and they are survived by the applicant and her minor sister. Grandfather is 90 years old, my lords. My application is only seeking that the notice stuck on the door. In fact, my lords, I would draw your attention for a moment. I would draw your attention for the objections filed by the OL. The OL has produced photographs of the door, my lords.
Objections filed on?
My lords, the OL's objection dated is 19 Jan.
It is on 21st January we have filed, my lord.
My lords, I guess it's page number 13. The objections that is served on me is not numbered, my lords, but I think it is page 13. My lords, this notice is the same notice that I have produced at Annexure D.
Page
28, my lords, of my application, Annexure D. They have taken symbolic possession. The OL has taken symbolic possession and he stuck this notice in a way that I cannot enter my house. My only request is I am not here to interfere with the liquidation proceedings. In fact, the respondent number 2 has pointed out he must appreciate the fact that this court has wound up and it is in liquidation today. That whatever claims will be considered. He's only made a performer part of this application because he's the petitioner in the original COP. I have no prayer or claim against the respondent number 2. My only prayer before your honors is that this notice be put elsewhere and not in the door, and I may be permitted to live in the door. I may be permitted to live in the house.
May I submit, my lord?
Let him complete. Let him.
Oh, very well, my lord.
Well, the OL has also come up with a condition saying that this property has been mortgaged with 4 and the 4 has taken physical possession. My lords, I put it to you across the bar that the applicant is the only person who has access to the house, my lords. He is the only key holder. And whether and 4 is not taking physical possession, my lord, it is a negative, and I cannot prove a negative. In fact, the court may direct me to prove that I am the only key holder to the house and I am the only person who has access to the house. I may do it today itself, my lord. But I'm putting a word across the bar, my lord. The 4 has not taken physical possession. They have mortgage, and that is not an issue. My only request is that, my lord, that notice that has been put across the notice that is stuck on the door be put elsewhere. In fact, I will myself, the applicant itself has also, I have also received instruction that she will erect a board and that can be put on that board and I may be permitted to live in the house. My livelihood is at stake. I have been survived by a minor sister as well. She's pursuing her education. Exams are going to become forward, my lords, and all the medical necessities and all the day-to-day living belongings are in the house. And the OL has taken possession on 8th November. Since 3 months that has been locked and I have been moving around places to places. My parents have abandoned me. Grandparents are old. I cannot rely on them. It has become difficult for us, my lords. My only request is that notice be put elsewhere and I may be permitted to live in the house. In fact, I am not interfering with the proceedings. Liquidation proceedings has made. These are my submissions, my lords.
Yes, OL, what do you say?
My lord, I have filed a detailed objection whereby I have clearly stated that the possession is with Ford Company. Last occasion also, when the matter was argued, it was put across to the council that he has not made Ford Company as a party. And if your lordship may kindly see, we have only symbolic possession. We don't have the physical possession of the Ford Company has got the full possession of that. And the applicant's grandfather, he's the ex-director, and he's not giving the applicant is not even giving the whereabouts of the directors. That is the grandparents. That Pandurang Shetty is the grandfather, who's the ex-director. They are not giving his whereabout. Official liquidator has only put the notice on the door, and physical possession is with the Ford Company. That if your lordship may kindly come to the objection filed by me at para 8 below.
Yes.
Para 8, I'll just read, my lord. Your lordship gets, my lord, para 8.
Yes.
That it is Mr. M.K. Pandurang Shetty who had identified the registered office of the company, and as could be seen from the above minutes, the proceeding took place in his presence and the symbolic possession was taken in his presence. The officials of the official liquidator informs that the said Mr. Pandurang Shetty is informed that the said premises has already been taken possession by Ford Finance Limited, and in view of none of that, present ex-directors handing over the physical possession of the registered office premises, officials of the official liquidator has taken symbolic possession of the same and pasted a notice. And this objection is already served on the council also. He has not objected for this. If he has any objections, he should file objections that Ford Company has not taken possession of that. Last occasion also, it was suggested by this honorable court that he should make Ford Company also a party because he is asking a relief, which is in a possession of Ford Company and not official liquidator.
Now you take out notice to that Ford Credit India Private Limited. I'll permit you to take out notice by way of hand summons. We'll hear them and then we will decide the application. Now, insofar as if you are actually in physical possession, then it's only a symbolic possession that is handed over to the official liquidator. Now, who is in possession? Let Ford Credit have its say, and then we'll pass an order.
Very well, ma'am.
If I may permit it to make a
Yes.
summary.
Yes.
My lords, I am putting a word across the bar, my lords. The applicant is the only key holder to the house. Your lordship is very much aware of the fact that once the Ford financial institution has taken possession, they also erect a notice on it. There is no such notice on the
So let us see. Correct. Let us see. Now, if any proceedings are initiated for recovery from their end, then who has mortgaged the property, let it come out. Let us see. And then we'll pass orders.
It has been mortgaged, my lords. I'm not disputing any of those, my lords.
Let us see, but we don't have a copy of the mortgage documents. Let the company come, put its claim, and then we'll see what is to be done. Whether it is you or the Ford Credit who has a better say, prima facie, if they are convinced, then we'll pass orders. After all, only symbolic possession is being taken by the official liquidator.
My lord, one submission for the consideration of this honorable court. May I, my lord?
So that we'll see. We are aware that OSA is pending.
Please,
we'll see that.
In fact, there is an affidavit government to say I am not aware where my father managing director is, but he is on wakalat before the division bench which is filed. So that is one.
No, that we'll see.
Please,
that we see.
Please.
The CA 3. This is 330, is it?
Please,
yes, ma'am. Yes, ma'am.
CA 330 of 2021 has been filed.
Because before your lordship proceeds, I have one small submission.
Yes.
Because in the interim, I may at least to take my necessary medical belongings from the house, my lords, with the OL's presence, my lord, the officers from the OL's office presence.
No, we are not in possession. He cannot put oil in the front. When we are not in physical possession, he cannot put us in the front.
My lord, I am in position, my lord. In fact, I was living there in the applicant.
We are not aware. That you are in possession, we are not aware. We have
Now
done.
let us see. Now let that agency appear, and then we will pass immediate orders. You take out notice by way of hand summons also. Now, which is your application? CA number?
330 of 21, my lords. That is the only application.
330. CA 330 of 2021 has been filed by the applicant seeking for a direction to the official liquidator to remove the lock and seal and hand over possession of the residential property. While the statement of objections are filed by the official liquidator, it is submitted that actual possession of the property is with Messrs. Ford Credit India Private Limited, address at Annexure D, page 70. And accordingly, it is submitted that the said entity is required to be heard as the petitioner has merely taken as the official liquidator has merely taken symbolic possession. It is appropriate, taking note of the prayer made in the present application, that notice of the said CA be sent to be served on Ford Credit India Private Limited in order to have their say in the matter as well. The applicant is permitted to array Ford Credit India Private Limited as an additional respondent. The court is of the opinion that application that Messrs. Ford Credit India Private Limited would be a necessary party. Accordingly, Ford Credit India accordingly notice to Messrs. Ford Credit India Private Limited. Yes. No, the applicant is permitted to take out notice by way of hand summons to the said entity as well. Notice returnable by list the matter on 24th. 23rd, list the matter on 24th.
Obliged.
179. You file it. It's not put up.
13. My lords, I appear for the petitioners in this case, my lords. My lords, these are applications by the executors asking the depositors to deposit the money into the testatrix account. My lords, it appears that the respondent number 2 has not been served. I'll ascertain the correct address and take out steps once again, my lords.
Steps.
Yes.
For service of notice on R2.
Great.
Yes.
My lords, serial number 13, my lords.
Yes.
List 3, my lords, I'm appearing for R2, my lords. A copy of the petition may be served on us, my lords.
Yes. Learned counsel, in whose name we are going to put in appearance?
For respondent number 2. Respondent 2.
Yes, counsel. Name of the counsel.
Manmohan PN.
Learned counsel Shri Manmohan PN undertakes to file wakalat for the second respondent.
Great.
This is the matter week after next. Yes.
Great. Great. My lords, I appear for the petitioner in this case, my lords. My lords, all the petitioners are residents abroad. Lords may give me 2 weeks time, my lords, to file the accounts.
A request made on behalf of the petitioner. List the matter after 2 weeks.
Grateful, your lordships.
Lord, I appear for the petitioner in this case. Lord, the reason for the delay in filing the additional accounts is because some of the original share certificates have been misplaced. So we have taken out a paper publication and filed a police complaint in that regard. Lord, may I be given a time period of 4 to 6 months, my Lord, to comply, because the company says it's a long procedure to issue duplicate certificates. So on that light, 4 to 6 months may be granted, and I'll file the final accounts.
Is the matter month of in the second week of June. A request made on behalf of the petitioner.
Obliged, my Lord.
Number 16. Number 16.
Yes, Mr. Disa.
I'm appearing in number 16, my lord. I seek 3 weeks time to do the needful in this matter.
At request of counsel for the petitioner, list the matter after 3 weeks.
17.
Obliged, my lord.
Open. 17.
Right, there are several opportunities. List of inventories and accounts not been filed by the petitioner. Issue court notice to the petitioner's counsel. Returnable by. This is the matter.
23. 24.
This is the matter on 24.
Number 18.
I'm appearing with official liquidator, my lord. This matter has been entrusted to my colleague, Mr. Mahadevan.
Just 1 minute. Just 1 minute. Yes.
I'm appearing with the official liquidator, my lord. This matter has been entrusted to colleague Mr. Mahadevan. He has gone to Chennai for an official liquidator's work only, my lord. I mean, mad case only. So if your lordship can accommodate for 2 weeks time, my lord, he will appear in the matter.
The matter. A request made on behalf of the official liquidator on 24th.
Obliged, my lord.
The same stage.
19.
In this case, I am appearing for the respondent number 2, my lord.
My lordship, I represent the respondent number 1, my lordship.
In the first petition, my lord, I request, my lord, on IA number 1 of 2019, filed by the petitioner is not served upon me. Of course, I filed an objection to the main petition, first thing. The main, first submission is, my lord, unfortunately, I have not received a copy on IA number 1 of 2019 filed by the petitioner, review petitioner. And I will file objection. Second thing is, my lord, I request this is connected to CA number 1185 and 11 CA number 1188 of 2015 and 1627 of 2013. It may be posted along with it because the property is CA number 1188 of 2015.
And
connected CA number 16727 of 2013. All are connected there. Your Lordship wanted to hear the matter itself.
Your Lordship, if I may.
1627 of 2013.
Your Lordship, this only the properties are the same, my lord. Subject matter is not the same. A connection is not warranted. In any event, this review petition has to be dismissed. It is on the basis of law, it is not maintainable.
Of course.
Let us see.
Connection will only, my lord, those matters which learned counsel is referring to are under inquiry. They will
No, not inquiry, sir. For hearing only. Your Lordship has posted all the matter for hearing. This matter is hearing also. Your Lordship will check it up through email.
Sir, I'm supporting the case of respondent to this. My lord, may I be permitted to?
No, if CA 1188 and 1627 is at the stage of inquiry.
No, not sir, fine, my lord. It is not inquiry, it is for hearing. The reason is, my lord, your Lordship wanted to hear all there are 4 petitions, dividend CA number 44 and also. Then, because of some the respondent wanted to hear physically, therefore the court adjourned it. I said I'm ready, but the court wants to argue before court in physical hearing. Therefore, it was adjourned.
My lord, on point of
connected properties connected to each other. That's it. Because that I contend the fraudulent act.
My lord, if I may just take 1 minute of this court's time, my lord.
I'm standing here, both of them are not.
My lord.
Just 1 minute, I'll come to you.
Please.
Whereby the state proceedings was thought to be distributed among 3 separate creditors. I have filed this review petition contending that the property which was sold by the liquidator is charged to KSIDC. KSIDC had a first charge over the property, and remaining 2 other creditors had not charged over this property. Therefore, the entire sale consideration received should have been paid to the KSIDC, being the first charge holder. Is my case. But in the applications which Mr. Money has referred to, those 2 applications are filed by the most respondent hearing, that is Canara District Central Cooperative Bank. It claims that not even prior to the order of winding up, there was an order of attachment of the very same property which has been sold by the liquidator, passed by a joint register of cooperative society. And therefore, the Central Cooperative Bank had a first charge over the property, and therefore the sale itself is void. Therefore, my information. I am contending that I am the first charge holder, and Canara District Cooperative Bank is saying that I am the first charge holder. That has to be decided first. Only thereafter whether the distribution of dividend is proper or not will be assessed. Therefore, it needs to be connected along with CA 1188 of 2015. This has a direct bearing on the result of the other company.
Yes, Rishad.
My lord, please, my lord. I am not disputing any of the facts, my lord. The law is the creditor has to elect to stand outside the winding up and realize his security, or he has to relinquish and stand in line and collect monies from everyone. In this case, the petitioner has not stood outside winding up, my lord. As an official liquidator, I am not his agent to enforce his security and give money only to him. Once he has not chosen to stand outside winding up, as per 529 and 529A, when I make the sale, I have to give money to workmen and secured creditors, irrespective of whether they are secured for this land or other land, in same amounts, my lord. The act of choosing to stand outside winding up is not done by this petitioner, and hence they are not, and hence the order that they are seeking to review under OLR has no defect that has to be cured, my lord.
Let us see. We'll hear the rights of all concerned and then decide what is to be done.
Please, my lord. I request the respondent to serve copy of their objections on the OL, my lord.
Because identical issue, whether the first class holder will have a preferential right to receive the entire sale consideration from the FD, subject to the dues of the workman. You will also have considering the other matter where Mr. Vinay Kumar was taking from the ASFC. In fact, on that time, I have contributed to some before. Even that the rights under section 48 of the Constitution is not taken away. Notwithstanding the fact that the company is not owned by the the preferential right of the first class holder will remain the same. That has been considered by the Honorable Supreme Court. And in the case of ICICI Bank versus Sixo Leather, it has been explicitly stated by the Honorable Supreme Court that right of the mortgager is not taken away. Let us see. But it is an important question as regards the company court is concerned.
Is the matter.
My lord, if I may make a request, my lord.
Yes.
The objections filed by other respondents is not served on official liquidator, a copy of that, my lord. And in addition, my lord, the case law which counsel for petitioner is referring to, it was not audible. If you may share a copy, I'll also evaluate and respond.
Yes, yes, yes.
My submission, my lord, one more submission. IA number 1 of 2019 copy is not served upon me. My learned friend may send it. I have no objection.
Yes.
But Vivekanand, I request Vivekanand to give a copy through email.
List put up records in CA 1188 of 2015 and CA 1627 of 2013. Full stop. The council on record appearing for the applicant as well as the respondent to serve all pleadings concerned to the counsel for the official liquidator as well. List the matter on 24.
Mitchell, serial number 20. Yes.
I appear for the respondent, my lord.
Appear for the petitioner creditor, madam.
Yes.
File an application under winding up of the respondent company, madam. Facts are this, madam. The petitioners are entered into a warehousing service agreement in the year 2012. Because the agreement is in the objection, madam. It's the first
Next year, you appear for the petitioner.
I appear for the
Next year,
it's annexure R1 in the statement of objections filed by the respondent.
yes.
First was agreed that the agreement lasts for 5 years. So, in the course of 5 years, we've provided all the services that are mentioned at clause 2, 2.1 services. All the services were provided, and in respect of the services provided, invoices were raised. Invoices are at annexure E, 75 to 82 of my petition. 75 to 82 of my petition.
Yes.
So, the respondents have paid all the invoices except one invoice, which is at page 82, which amounts to 15,74,546. They paid all the other invoices on page which are at page 78, 79, 80, 81. But they failed to pay this one invoice, which amounts to 15,74,546. In respect of this invoice not being paid, we issued a letter to them saying that the money be paid within 1 week. So we followed up with them, and those letters are at annexure F and annexure G, 83 and 84.
What was their response?
response is at annexure J, my lords, 88. '93 is what they're claiming the reply notice, my lords. '93, the equipment is given to a client in a condition which is no different from the condition in which it was removed from the premises of the client.
Is
93, my lords.
of the same document.
Of the same document, of my petition. Annexure J.
Yes.
They said since our client would need to continue its warehousing services for its own purposes for which it would require the equipment, our client is willing to consider buying back the equipment from your client subject to the following conditions. They say this 15 lakh refers to this one equipment that we had bought, which they were using as part of the warehousing service agreement. Now, since they're not able to do the same, buy back the equipment. But one issue here, they have terminated the agreement. By the email dated 21/1/2013.
No, now that equipment belongs to you, and you had given it to them as a part of the agreement.
As part of the agreement. So what has happened here is, my lords, on
Now you wanted that equipment back.
no, my lords, I had purchased it for their services. So I paid certain amount for that equipment. So the invoice is in respect of that, my lords, 15 lakhs. So we are seeking that invoice, my lords, in respect of what was not paid as part of the agreement.
So according to you, since they terminated the agreement and that equipment was purchased for their benefit.
Benefit.
You're seeking.
Because the email dated 21/1/2013, this letter is issued on this reply notice is issued on 7/1/2014. So they've terminated my agreement prior. So my only recourse there was arbitration. Lots of
No, now they want to buy that equipment itself.
Yes, my lords, but now that since I've terminated the agreement, everything stands as nullity. There's no agreement in place. That's why I've come before this court.
Correct. Now, in lieu of the amount that you have claimed, if they're going to purchase it and pay you some amount beyond that, then it could be settled.
Very well. If that is the case, we need to do it.
Yes, what do you say?
My lord, may I make the submission? My lord, there was an agreement which stood terminated for reasons because my client had a problem in conducting the business. Thereafter, every month, monthly, and they are aware of it, monthly rents were paid. In this agreement, there is an arbitration clause where if any dispute, he can refer to arbitration. But they refused, they did not go for arbitration. They hastily came before this court for a winding up, suppressing many facts, my lord. The basic fact is these equipments, if you may see annexure R2 of my
Correct.
statement.
No, I'll come to
Page
that.
35.
I'll come to that. Now,
Yes, my lord. Yes, my lord.
Annexure J is a communication addressed by you.
Yes, my lord. At that time, I had told them, I'm not, it's my communication. But if you're in this annexure J, which is my reply notice, which you may see on page 90 of that annexure, para 6. Para 6, page 90, my lord.
Yes.
Our client represents to us that it is utter shock and surprise. In April 2013, our client received an invoice of the 3/4/2013 raised by our client for a sum of rupees 15 lakhs 74,540 towards amortization of asset usage. Amortization of asset usage for Lab India Bhopal, hereinafter referred. Our client informs that their client was surprised to receive, considering the basis that the equipment was agreed to be paid by our client, the understanding that they will be entitled for the use thereof, and that your client has already taken away the equipment of termination, in all probability using it somewhere else, and accordingly being used by our client. Our client informs us that accordingly, our client did not make any payment towards the invoice since it's not liable to pay the amounts indicated therein. The invoice issued by our client is a blatant way and means of extort money out of our client by blindly inserting the unamortized value at the month-end figure in Exhibit D of the agreement for the month of April 2013. Our client informs that your client also received the payment reminder, which is to pay the outstanding amount, and we have paid it. To this, our client promptly issued a letter dated 29/4, which I have 29/4/2013, stating that they have paid full and final. I have made payment. I have also filed that they have taken back the equipment. My Lord, in my statement of objections, if your Lord may see Annexure R2 and R3. R2, R3, which is on page 35 and 36 of my statement of objections.
Yes.
On 19/4, the petitioner, as this is to certify that we are sending all these racks, they are sending it to themselves from our location, from this location. The petitioner, they have taken back all this for transportation. They valued it at 4 lakhs. Then again, there is one more, Annexure R3, page 36. The other different equipments which they have taken back. This is on 19/4. Again, again on 29/4, which is Annexure R4. Annexure R4, I have given them the details and paid an amount of 8,73,558, which is due to them. This, in view of the aforesaid, we hereby confirm having paid all the monthly warehousing service invoices as signed between us in the contract, and no further payment is pending at our end. So my Lord, I have paid them the full money. If at all we have any dispute, they have to go for arbitration. Thereafter, they find a rejoinder. You please see the rejoinder they have filed. In the rejoinder, if your Lord may see page 8, they go on saying that after termination of the warehousing
Paragraph?
page 8, paragraph 12, page 8. Paragraph 12, the bottom line, last line, that is the 4th line from bottom of paragraph 12. Hence, after termination of the warehousing services on 25/6/2012, there is no question of invoking arbitration clause, as arbitration clause is part of the said agreement and also co-terminates with the agreement. In other words, arbitration clause has spent its life and the contention. When there is an arbitration clause, they knew that they could go for arbitration. They are seeking money based on this agreement. And then they say that there is an arbitration, no arbitration clause survives. Even on page 9, if you may see, paras A, B, C, they keep on saying that there is no arbitration. Your Lordship, there is Supreme Court judgment which says when there is an arbitration clause, they cannot come.
Now that question is to be decided by the competent court, and if there's a dispute, either now he claims that the arbitration clause is no longer in operation. Whether that is so or not is to be decided by the court while referring the matter for arbitration. Now, if there is a dispute, you invoke the clause. You only initiate the CMP proceedings. Let the court decide whether the arbitration clause is subsisting or not. Now, that is that one part of it. If there's any way of settling the matter amongst yourselves, you let me know. Then we can refer the matter for mediation. You explore it. If it is not possible in mediation, then by default the arbitration aspect will have to be considered.
Yes, my Lord. Okay. As your Lordship says, my Lord, because they have taken the goods, they are enjoying it from 2015. They have taken everything. I have nothing. I paid them in full and final. That is what I've been telling them. I have no thing. You take the goods back, you take the money back, and then you say, pay me for the goods. They are keeping the goods. They haven't come and told this code.
Let us see. Now I'll refer it for mediation.
Yes, my lord. I have no objection on that.
Yes, see.
One submission. They say 90 the reply notice. The client would be willing to pay for such equipment. The value are determined by a third party.
Let us see.
We have no problem. That is the way that they can come through the mediation.
From then, they have not even been coming to say that at that time they should have replied instead of coming before this honorable court.
Let us see. Let us see. Let us see. Yes, Same Kumar will give you some different assignment. So you will appoint you as a mediator, and then you can look into it. Now the terms you discuss with the mediator and settle the terms and the fees of the mediator amongst yourself. You do it.
Yes, ma'am.
In light of the nature of dispute, after having heard the matter for some time, it is there is the both parties consent upon suggestion by the court that they would attempt to amicably resolve the dispute by way of reference to mediation. The matter is referred for mediation, and Shri Hemkumar so-and-so is appointed as a mediator to explore possibility of amicable resolution of the dispute. The terms including remuneration payable to the mediator are left open to be discussed and arrived at, and conclusion arrived at by the parties. Necessary records to be transmitted to the mediator.
Madam.
Serial number 21.
I appear for the petitioner in this matter, my lord.
Yes.
I appear for respondent.
My lord, in the last occasion, your lordship.
Yes.
My lord, in the last occasion, your lordship had asked whether the parties could have any discussion. I spoke to my client, but they have no, and I also spoke to Mr. Muralidhar. He said, why not they talk? But the managing director, he expired, his son has taken over, and they are not in touch with the respondent from 2020. Even whatever equipments that they have taken, a lot of all those equipments are not being serviced by the respondent. Absolutely, they have no connection as to who they should contact in the respondent company. If your lordship appoints another, because last mediation did not take off, and as your lordship is aware, in the last occasion, if your lordship again wants to appoint another mediator, we have no problem. Or if my learned friend gives me who the contact person is, and also from their side, we will work out a settlement.
Yes, what do you say, madam? Yes, respondent.
I appear for the respondent, my lord. We have already communicated to the head office about the settlement.
Correct, but you must come back with some and arrange for a meeting so that both of you can sit and see what is to be done. You'll have to find out who is the person from the respondent company who will be in a position to take a decision, communicate to the other side, and arrange for a joint meeting.
Yes, my lord.
You find out by the next date. I'll relist it on 24th. By then you get details of who is the person in the respondent company who will be in a position to sit across and solve this problem. Otherwise, we'll have to proceed on merit.
Yes.
Yes, my lord.
Relist the matter on 24th. Counsel for the respondent to take necessary instructions regarding the possibility of settlement by the next date. Yes.
Much obliged.
Much obliged.
Seal number 23.
How much time you will take? I'll pass over. I have one partnered matter. Afternoon, I have a bench. So if it reaches, we'll have to take it in this half itself. So I'll pass over. If time permits, we'll take it. Pass over. Afternoon, I have a bench. So first, 22nd. The matter on 21st. Let us see on 21st.
Lords, I appear for the petitioner, my lords. This is a wife's petition for letters of administration. Her husband passed away interstate on 21/9/2019. I may be permitted to carry out citation in Indian Express, Bangalore edition, and Kannada Prabha, Bangalore edition, my lords.
Yes, how many children? Children, what about?
Lords, no children, my lords. No issues, my lords.
It is submitted by the counsel for the petitioner. Husband of the deceased.
The husband of the petitioner, my lords. The wife of the wife of the deceased.
Husband of the petitioner had executed a will.
No, my lords. He died interstate. No will. Letters of administration.
Died interstate.
Yes, sir.
And there are no other children from the wedlock.
Yes, my lords.
And accordingly, petitioner is legally the sole heir.
Yes.
Issue citation to be carried out
in Indian Express and Kannada Prabha, Bangalore edition.
Indian Express and Kannada Prabha, Bangalore edition.
Yes.
Now the properties are
only in Bangalore, my lords. One house.
The citation to be carried out
on or before 24th February, hearing date 10th March.
On or before 24th February, matter to be listed on
10th March.
10th March.
Great for your lordships.
IA1 of 20. What is IA1?
IA1 is for dispensation to notice to the Deputy Commissioner, my lords. We have undertaken to pay the entire court fee, my lords.
Right off. The submission that the petitioner undertakes to pay the maximum fee provided under Article 6B of Schedule 1 of the Karnataka Court Fees and Suit Valuations Act. Notice to the Deputy Commissioner is dispensed with. Accordingly, said application is allowed.
Great for your lordship.
Passover, will take it up immediately. Passover, will take it up immediately.
Number 2, NKG.
My lords, I appear for the petitioner in this matter. The impugned order at Annexure A, which is at page 51.
Yes, just 1 minute.
Yes, my lord.
Commissioner of Central Tax. Is he there? So let him come. We'll pass over. Let one of the council come. We'll pass over.
My lord, this is essentially an appellate order. Impugned order is an appellate order against which a statutory appeal lies to the tribunal, appellate tribunal. But the appellate tribunal is yet to be constituted. In view of which the writ petition is entertained by this honorable court in all matters.
Yes. No, that will entertain, but you are seeking for some interim relief. You are seeking.
Yes, my lord. That prayer may be kept open, my lord, and on next occasion also it can be.
Yes. Issue notice to the learned counsel Shri G1 accepts notice for is directed to accept notice for the respondent. Request for interim prayer is kept open. Copy is to be served on the said council forthwith. List the matter in the first week of March.
Oblige your lordship.
Copies to be served.
Yes, my lord. Yes, my lord. Today itself I'll get it done.
Number 3, Sirumalesium.
The cancellation of registration GST has challenged the
Now you will accept notice. He accepts notice for the respondents. Serving copies.
when you said this,
Serve. We'll have it next week. You take instruction. We'll have it next week. Let us list the matter. The orders list for consideration of interim prayer on 20. So when do you want it? When do you want him, Kumar? When do you want? This is the matter on 16th. The matter orders list. Yes.
I'm appearing for the petitioner, my lord. The petitioner company is challenging the notice issued under section 148 of the Income Tax Act without following the procedure of section 148A, which has been implemented with effect from 1/4/2021 of the amended provisions of the Finance Act.
Date of notice?
The date of notice is wide annexure A, my lord. It is 30/6/2021, my lord.
Arvind
Subsequent to the amendment of the Finance Act.
Yes. STV Arvind accepts notice for the respondent. Same interim order. 48 years. It's a matter after 2 weeks.
Milord, I have sought for interim order, Milord.
Yes. Stay of annexure.
Yeah, Milord.
Yeah.
Number 5.
Deeply obliged.
Number 5. Balachandran BS.
WP 3098, my lordship.
Yes.
Lordship, this is a research organization which is promoted and controlled by 3 oil PSUs. That is BPCL, HPCL, and IOCL, my lordship. In this
Just
case,
1 minute. Just 1 minute. Assistant Commissioner of Income Tax, Deputy Commissioner of Income Tax, Commissioner of Income Tax. Learned Counsel Shri K.V. Arvind accepts notice for the respondent. What is the matter?
my lordship, here the entity is a research organization which has got the approval under section 35 of the Income Tax Act 1961, my lordship. This approval is granted by the central government. Now the assessing officer, for a delay of filing audit report before the concerned commissioner, which is a precondition, which is one of the conditions prescribed under section 35, he is withdrawing my exemption given under section 1021, my lordship. Section 1021 is exemption will be allowed as long as the approval under section 35 survives, my lordship. And unless the central government withdraws that approval given under 35, the AO has no authority, has no jurisdiction to withdraw, my lordship. However, by misreading the provisions,
he has overstepped into the authority of the central government, and he has withdrawn the exemption given under section 1021, my lordship. The amount was 7 crore, and he has raised the demand of 3.55 crores, my lordship. And my lordship, kindly see, there is a rule called Rule 5D. In this rule, if my lordship can come to page 3 of my petition, the rule very clearly, the heading is the conditions subject to which approval is to be granted to a research association under clause 2 or clause 3 of subsection 1 of section 35, my lordship. So this rule 5D relates to the conditions subject to which the approval has to be given by the central government. Now here 5D3, which is mentioned at page 3, it says that the research organization has to get its books audited and file the audit report before the due date, before the Commissioner of Income Tax. Now this particular section rule itself, 5D6, it clearly says that in case any of the conditions subject to which the approval has been granted is not being followed, then the concerned commissioner has to submit a report to the central government for its consideration. The AO has no role to play in either approving or withdrawing the section 35 approval, my lordship. Now, kindly see the assessment order, my lordship, which is at page 50.
Let us see. Yes, let us see. Let him take instructions, and we'll
Okay,
consider interim prayer on the next day.
Interim player also, my lordship.
On the next day, we'll
Okay,
consider it on the.
Okay,
list the matter. Learned counsel so and so accepts notice for the respondent. List the matter in the orders list for consideration of interim prayer on
24th, my lordship.
24th.
24th, my lordship.
24th.
Oblige, my lordship.
Number 6. Joseph.
I appear for the petitioner, my lordship. On behalf of senior, kindly pass over the matter.
Okay, pass over next.
Correct.
I appear for the petitioner in this case, my lord.
Yes.
On the last occasion, I had made a submission, my lord, that the petitioner before this honorable court is a transporter. While transporting the goods, partly unloading in one destination, and when he was traveling to the second destination, unknowingly he had taken a wrong route. Therefore, the respondent has intercepted the goods vehicle, and all the documents are tendered, and notice was given. Notice was replied. Subsequently, passed an order challenging that order, my lord. I appeal before this honorable court in the form of a writ petition, wherein this honorable court stated that there is an alternate remedy and you exhaust that remedy. By virtue of this, I appeared before the first appellate authority. The first appellate authority has rejected my appeal. So therefore, now again in the second round of litigation, I have come before this honorable court. The facts of the matter, my lord, that vehicle is innocent, my lord. My interim relief, what I am now immediately requesting before this honorable court is that the vehicle is innocent, my lord. In order to detain the vehicle or to confiscate the vehicle, section 130 provides him to initiate proceedings against the goods conveyance. In the present situation, my lords, there is no initiation of proceedings under 130. So therefore, pending consideration of the immediate interim relief would be release the vehicle, keep the goods, and probably next week when it comes for hearing, my lord, they can come up with. But for more improvement, my lord, it's a national permit vehicle. Every day I'm incurring about 6,000 rupees for no fault of mine.
Yes.
And it's a national permit vehicle. So therefore, my interim relief is urgently required for the release of the vehicle, my lord.
Yes, M. Kumar. Okay.
He has not entertained the appeal on the ground that 10% of the disputed amount has been paid. I'm not saying this order cannot stand. 10% of the disputed.
Only on that ground he has dismissed.
Only on that. It is not considered also.
Correct, but these people are familiar with all this, isn't it? Day in and day out they deal with appeals. In the sense, I'm only saying that suppose it's a new issue, it's a different matter. Now, day in and day out, if they're dealing with matters, then they should know.
Page number 96, the 10% is remitted, madam.
What I would suggest is on the direction will be issued to the hospital for disposal of appeal on claims, including the condition with regard to the issue.
The goods vehicle, what is the normal procedure now?
Because as we learned today, if the amounts are not paid, then we start proceeding under section 130 on this case. This case was where it was under litigation. So they could not take any further steps by initiating under 130. Because the matter was sent before the 4 minutes, they had to go back to 129. Amounts are not being paid. However, they pay 10%. And it is a case of the petitioner that they pay 10% of the tax. This order, I should submit assisting the board. This order will have to be certified, and the matter will have to be remitted back to.
Correct. Now, vehicle, now so many days it's kept. It's a.
Vehicle, in fact, whatever is dated 13/1/2021.
Yes.
In fact, we got March 96. Here on.
Page. $76, is it? 76.
$76 is the judgment of this honorable court at the first instance. When I appeared
Page 79, paragraph 6 and 7.
Now that's correct. So what we'll do is, because of this order, now we are again sending him back. If there is some procedure for release of vehicle, we'll order that and ask him to take up the retake up the matter on merit.
one section. Section 130, my lords.
Fiscal knowledge is not maintainable in the item of the application for application for in pursuance of order part of the song of the 10/1/2020. This is the tomorrow or day after tomorrow minutes regarding the release of the vehicle. It's our personal not to be directed to pass on to the money.
Now we'll set aside this annexure A and we'll remit it back. You appear before the authority day after tomorrow. Within 1 week, we'll ask him to dispose of your application regarding release of vehicles.
My lord, one respectful submission, my lord. 2 months ago, my vehicle is detained. Section 130 could have run parallelly if they were interested to initiate proceedings against the goods conveyance. That clearly shows they have no intention as far as the vehicle is concerned. So therefore, as of now, they have not initiated. Section 130 subclause 2, my lords, it says he has to give an opportunity and he has to fix a penalty. These proceedings are discussed in the orders. That is not the grievance of the officer. So vehicle belongs to someone. Person. What way he should be?
Because the matters are pending for dishonorable court. Then before the first appellate court. If the pendency of
the first appellate will not decide on the vehicle, my lords. He has no authority. Only I can, under 226 and 227 only I can pray before this honorable court, not before the first appellate authority.
What M. Kumar?
And
what is the position? No, just one. What is the position? No, we'll record that. They will consider it within 1 week from tomorrow. They'll consider it and pass orders. We'll set aside annexure A and send it back. If within 1 week they don't, then we will see what is to be done.
Lord, this is my second round of litigation. When all that my mistake, my lord, I have taken a wrong turn, and I was my lord. So therefore, at least the vehicle may be disposed, my lord, because the appellate authority has no jurisdiction, because they will not interim players, my lord.
We'll direct him within 1 week to pass orders while noticing the direction passed in the earlier writ also.
No, my lord.
1 week.
On the vehicle, he will not be able to pass any orders, my lord, because there is no proceedings. Under 130, if there is a proceeding, then I have to challenge it separately. Where is the proceedings under 130 or 130 clause 2? They have not initiated anything. There is no whisper. That means they do not have any grievance as far as the vehicle is concerned. Let the vehicle be released, my lord. It's a national permit vehicle. It belongs to some third party, and I am put to severe inconvenience. I am only a transporter. I have hired this vehicle, my lord. Every day I am incurring. It is a jeopardy. Vehicle is innocent. Otherwise, 2 months ago, you could have parallelly initiated under 130. How will the appellate authority decide on 130, my lord, when there is no question of it? I cannot see.
No, they are not. As of now, no proceedings under 130. That is a stand by the authorities.
Yes, my lord.
So far as vehicle release, they'll consider it within 1 week from tomorrow. We'll send it back. If it's not passed, then we'll reserve liberty for you to seek for a revival of the writ.
At least I will replace the vehicle, my lord. It's a national permit vehicle. I will shift the goods to another local vehicle, and I will furnish a local vehicle, my lord. Why
within 1 week, failing which we will give you liberty to move this writ petition. Now, which is that?
Yes, my lord.
Which is the 10% of disputed, which is a provision?
107(6), my lord. He is misinterpreting the law. It says on the tax, my lord.
107.
107.
Yes. Ten percent of amount of tax in dispute.
Yes, my lord. The tax in dispute, my lord, is at 7 lakhs, my lord. At page 49, may I draw your lord's attention to page 49, my lord. Top order under section 129(3) under KGST Act. Other Kelgade under CGST. 3,85,000 plus again same amount 3,85,000. 7 lakh and odd agate. Adra to 10% I have remitted. Now he is interpreting all tax under it includes the entire amount on theatre. He has levied me about 48 lakhs. He says of the 48 lakhs,
it's only on the tax.
Yes, my lord.
The section has been further amended with effect from 1/1. It was amended, but it was being notified from 1/1/2022, saying that in case of penalties levied under section 129(3), 25% of the disputed amount has to be 2021 initial.
But insofar as this case is concerned, it will be the pre-amended. Because as on the date, that is the law. Yes. Now, where is this dismissal of the appeal?
One minute.
The petitioner has called in question. Has asked for setting aside of order of the first respondent dated 17/1/2022 at annexure A and setting aside of the order of the second respondent at annexure A1. Full stop. The petitioner submits that the appeal filed has been dismissed on the sole ground that the statutory payment of 10% in terms of section 107 of the CGST Act 2017. 107 within bracket 6 within bracket D of the GST Act has not been complied with.
Annexure H, my lord, my payment. Annexure H payment.
The
96.
petitioner submits that the required amount has been deposited, as is evidenced from the
Annexure H. Page 96. Ink page.
required amount of 77,086.
Which is 10% of the entire tax.
Which is 10% of the
tax
demand. As mandated under 107 has been paid. Attention is drawn to Annexure H, which indicates payment of 77,086. In light of section 107 6B, the entertainment of the appeal is on payment of 10% of remaining amount of tax in dispute. In the present case, the tax in dispute is
3 lakh.
7 lakh 70,846. 846.
7,77,086.
Just go to page 30.
60. 7 lakh.
Page 30. Page 30. Just go to page 30 for a minute.
10%.
But down it says 70. No, which is the correct amount? Yes.
7,70,846 is the amount, my lord. Determine the tax of which I have paid the 10%. This is available at page 30, my lord.
It is 7,70,846.
846. 46. It is found in annexure at page 30.
In
the present case, the tax in dispute is rupees
70,846.
Yes,
and full stop. The 10% of the disputed tax would amount to 77,084. Full stop. In light of the payment made at Annexure H, the rejection of the appeal on the ground of non-compliance with section 107 6B is clearly illegal. Accordingly, the order at Annexure A rejecting the appeal is set aside. Matter is remitted back to the authority to take on board the take on board the appeal and proceed. It is to be noticed that this court, by order dated 5th January 22, while disposing of WP 2384 of 2021 and remanding the matter to the appellate authority, at para 7 had observed as follows at page 79. Next, learned counsel for the petitioner vehemently argues that his vehicle with a national permit has been detained, causing great financial hardship and loss to the petitioner, and that necessary orders need to be passed on the application for release of the vehicle. Next. Taking note of the observation made previously in WP at para 7 in WP 23864 of 2021. It is directed that the authority, while taking on board the appeal, is to take expeditious steps to pass orders regarding the release of the vehicle within a period of 7 weeks, 7 days, 7 days, 7 working days. If there is any lapse in that regard, petitioners at liberty to move this court and seek for appropriate direction relating to release of the vehicle. Accordingly, petition is disposed of. We'll release the copy today itself if possible.
One correction, my lord, while making 10%, 77,084 ಅಂತ ಆಗಿದೆ 086 ಆಗಬೇಕು 10% amount.
You have paid 2 rupees extra.
86 is the correct amount. I have paid 86. Yeah.
86 is it? 84 agalva ಅದು?
10%.
10% of that will be 84. You have paid 2 rupees extra. Correct?
Okay. Yeah. Much of it.
Number 8.
Here for the petitioner in this case, my lord. This is pertaining to, my lord, levy of GST on royalty and leases. My lord, prior to coming into force of the GST regime, service tax on royalty, my lord, is stayed by this honorable court as well as the honorable Supreme Court. After the GST, which are pending, my lord, after GST regime came into force, my lord, several petitions.
Just 1 minute. Just 1 minute. Yes, sir. Who will take notice in this?
GST.
Yes, the other respondents. The others? Or? Who is there? Learned counsel. See, so and so undertakes to file wakalat on behalf of the first respondent. AG accepts notice for the fourth respondent. Learned counsel G1 is directed to accept notice for respondent 2 and 3. Now let him come, we'll pass over. In his presence, we'll see what is to be done.
I can only make one submission, my lord. I'll wait. Annexure K, the Honorable Supreme Court had granted the interim order. Subsequently said, Annexure K, page 210. These were all petitions under 32. The Honorable Supreme Court had entertained and granted stay. Subsequently said you file petitions under 226. As far as service tax, my lord, it is pending before Supreme Court as well as before this Honorable Court. The very same petitioner also had challenged levy of service tax and royalty. This Honorable Court has entertained and granted stay order, which are pending.
Where is that order?
That is 1033 of 2017, my lord, where Mr. Niralgi, the learned counsel, appeared. That is pending.
WP 1033 of
2017, my lord.
You have enclosed a copy of that?
No, my lord, because I enclosed a copy of the Honorable Supreme Court order itself on GST.
So now you are saying that the same order passed in 1033 could be passed here.
That is regarding service tax, my lord. This is regarding GST.
Yes.
So if my lord would say, as in 210 page number, levy of GST on mining lease or royalty, my lord, should be stayed. Because before GST, service tax was stayed.
Yes. I'll make a note of this. I'll pass the same order in his presence. I'll just send word for him and we'll pass the same order in his presence.
Very well.
Pass over. Note money, draft money. There will be an interim order regarding the staying payment of GST for grant of mining lease / royalty by the petitioner till the next stage. Pass over. Okay.
Your Lordship, I appear for the petitioner. In these two petitions, the Lordship may recollect that the issue is whether sugar candy is sugar or not. I've been served with a copy of the clarification which is issued by the first respondent dated 8th February, Your Lordship. And as per this clarification, first respondent is clarified that Kallu Sakre or sugar candy is exempt from 2013.
What is the effect of the clarification?
Effect of the clarification is that I don't have to pay tax. Your Lordship. It's decided in my favor.
Last page of the clarification.
Yes.
If your Lordship will see that sugar can.
Just 1 minute. Just 1 minute. Yes, M. Kumar.
Sugar syrup and chocolate for different periods was given at Karnataka. Here it is only sugar candy. Another candy C for the period 6/11/2013 to 30/6/2017.
It's exempt.
Yes, your Lordship.
What has to be done with assessment part? And also to send back to the assessing authority. Pass a question assessment in your clarification. And it is only let there be a reminder only in sugar candy. Because there are other aspects before the appellate authority regarding the review of tax. There are some other issues also involved.
Now, if it is going to be disposed of in light of the clarification, then other issues will not arise.
Other issues are different. That's the kind of
So that will have to be reconsidered. Yes.
Page 19.
Page
19 is what about the authority. 21 NDC.
Yes. Yes.
These are the counts that are carried from the authority. Assessing officer. There is estimating without any basis tax on sale of candy. There is estimating purchase of sand. There is estimating purchase of sawdust. There is estimating sale of candy bags. There is levy of tax of interest in bank. So there are other grounds also to canvas. This should not be considered.
May I make a submission?
Yes.
So as sugar candy is concerned, then the assessing authority reconsider that.
So the demand will be insofar as sugar candy is concerned.
Your Lordship, if I can make one submission, Your Lordship.
Yes.
Your Lordship, I've challenged the impugned order on various grounds, including that this order passed by the Joint Commissioner is non-speaking order, and all the submissions that I've made is not considered. If I may request that let the order be set aside and the Joint Commissioner, the second respondent, decide all the issues afresh, taking into consideration this clarification and giving me an opportunity of hearing, leaving all the intentions open, Your Lordship. I will make all my submissions to the appellate authority.
Now the finding by the authority, there is no finding as regards the other grounds. Is there or is there no finding?
It is not speaking. All my submissions are not taken into to recount. Just one-liner observations are being made, Your Lordship. In fact, if I'm drawing Your Lordship's attention to page number 25.
Now, there's only 2 pages of the reasoning. You
Yes.
read from bottom of page 24.
Yes, Your Lordship. The DAR of the appellate argued that as per the Commissioner's circular number so and so dated 27/2013, the respondent has levied tax at 5% on sugar candy. But the said circular was withdrawn by the Commissioner by passing clarification circular number so and so dated 18/9/2018. Therefore, the DAR requested to delete the levy of tax on sugar candy. The said circular of Honorable Commissioner of
Just one minute. Just a minute. Now, insofar as the other grounds that they have raised, there is no finding except
saying that various issues like impingement. Whatever the grounds that is there is no dispute. We have not really found that, except saying that the order is not speaking. And others might be remanded to the first class authority.
Your Lordship, if I may be permitted to also obtain an opportunity of hearing on all the issues, Your Lordship, and all contentions may be kept.
Petitioner. Okay. Following question. Okay. Now both petitions are the same, is it?
Yes, different tax.
Same petitioner also different assessment.
Same petitioner. This petition.
Orders, correct. The orders are identical.
Yes, Your Lordship. Different tax periods.
So now you go to the next one. Just show me the assessment order. In 2766 also, show me the assessment order.
Assessment order is at Annexure D, page 35, Your Lordship. Page 36, the inspection report relies on, inspecting officer relies on the circular issued by the first respondent.
Just 1 minute. WP 2766.
Yes, Your Lordship. Page 30 is the assessment order.
Annexure A1, page 28.
Annexure D, page 35, Your Lordship, the reassessment order. Page 35. That's where the order begins. Page 36, the third paragraph, Your Lordship, where the assessment order is based on the inspecting officer's observation. Sugar candy is taxable at 5% as.
Just 1 minute. Just 1 minute.
Comes at page 29.
Same one.
Same one. Sugar and other the findings at page 30. The question is made whether the improved order passed to the respondent can be interfered with. It is answered in the writing. And point 1 is not anything. The appellant has preferred the Supreme Court in spite of many opportunities to submit in bracket. The appellant has failed to utilize the same to submit the necessary documentary evidence before the state to this state. He has only submitted the records of the reflecting the grounds of which without providing any documents to substantive state. More or less an expired order.
So in this matter, we'll specifically say one opportunity, and the other matter it is non-speaking. Huh? The first is the one. WP 806 of 2022. The petitioner has sought for direction to the first respondent to comply with the directions of this court by order dated 24/9/2018, passed in WP 26404 of 2017 as per Annexure E. Petitioner has sought for setting aside of the order dated 9/11/2021 issued by the third respondent in appeal at Annexure A, and further sought for direction to the third respondent to decide the issue in accordance with law. At the time of hearing of this matter, Government Advocate Shri Hen Kumar has produced a copy of the proceedings of the Commissioner for Commercial Taxes and draws attention to clarification order number CLR.CR-44 of 2012-13 dated 8/2/2022 and submits that as per the notification that the rate of tax as would be applicable for the period 6/11/2013 to 30th June 2017.
Till 36 rules. So the entries will differ differently. So for a particular period, so it's 8/4/2011 to 11/4 was taxable at 4%. In 12/4 to 31/7, 5%. Then 1/8/2013 to 5/11/2013 at 1%. And 6/11/2013 to 36/2013. Why I brought only this last one? Because it is relevant for assessment years. Clarification issue from 1/4/2005. That is the day on which the VAT Act came into force. Till the day the VAT Act was in force. That is 36/2017.
For the whole period.
Okay.
Then why is it set 4%, 5%, 1%?
Because the entry limits during the relevant period are different.
That's
Rate of tax as would be applicable for the period.
the rate of tax for the entire period when the
VAT Act came into force from 1/4/2005.
from 1/4/2005 till
The VAT Act was in existence 36/2017.
till 36/2017 would be nil, as it was exempt from tax as per the clarification. The rate of tax
is specified. For 2 periods it is exempt. For small periods it is applicable.
On
the
sugar.
from the entire period
From
1/4/2005
till 30th 6/2017.
17, the rate of tax for the various periods is found in the last column. Accordingly, it is submitted that the matter may have to be reconsidered by the Joint Commissioner of Commercial Taxes Appeals, which is the first appellate authority.
Yes,
Peruse the order at Annexure A. Insofar as the order of the authority relating to sugar candy is concerned, matter will have to be re-looked into in light of the clarification order referred to above. Insofar as the other grounds are concerned, as raised by the petitioner in their grounds of appeal relating to purchase of sand, purchase of sawdust, sale of gunny bags, etc. is concerned, though grounds have been raised, the authority has not adverted to such of the grounds. Accordingly, order at Annexure A is set aside, matter is remitted for fresh consideration. The authority to take note of the clarificatory order and the other grounds raised by the petitioner and pass a fresh order after giving opportunity of hearing to the petitioner. Next.
766.
This writ petition has been filed. Calling in question, seeking for direction to the first respondent to comply with the directions of this court while order dated 24/9/2018 passed in WP 24606 of 2017. They sought for setting aside the orders dated 6/4/21 and 30th/7/2021 passed by the third respondent at Annexure A and A1. And other reliefs have been sought for. After hearing the matter for some time, the government advocate produces copy of the clarification order number so and so, dated 8/2/2022. Last page, page 9 of the document. It points out that the rate of tax is provided for with respect to the period of 1/4/2005 to 30th/6/2017, and that the order at Annexure A1 will have to be reconsidered as A and A1 is to be reconsidered in light of the clarification order referred to above. Peruse the order at Annexure A and A1. It is noticed that the respondent, that the petitioner, is also not participated effectively and put forth necessary documents and evidence in support of claim for exemption. In the interest of justice, it is appropriate to remand the matter with a direction that the petitioner be given fresh opportunity to place its case before the appellate authority, while noticing that the matter requires to be relegated to the appellate authority in light of the clarification order referred to above. Accordingly, the order at Annexure A and A1 are set aside. Matters remitted for fresh consideration. The authority to consider the matter afresh relating to all contentions which are kept open, and is also required to take note of the clarification order while disposing of the appeal. Accordingly, appeal is allowed. Now, in that other matter, only one order, isn't it? Yes, yes.
Your Lordship, an opportunity of hearing
An opportunity of personal hearing may be granted to the petitioner.
Obliged.
Yes, Arvind.
Joseph only. Joseph. Karnataka. Passport matter number 6, Joseph.
Please, my lords. I'm sorry, my lords, I could not appear first.
6.
Yes, Kumar is accept notice. The council to appears accept notice for the respondents.
This is a case covered by the judgment of which is produced at Annexure E, my lords, at page 32. This is a case of levying VAT on freight charges.
Hem Kumar, you have the papers. So then when do you want it? Then in the interregnum, So you take instructions and so and so accepts notice for the respondent. Consideration of interim plea is kept open. This is the matter on 23rd.
Meantime, interim order, my lord.
Let us see on the next date. We'll decide on the next date. We'll decide.
Oh, bless you.
After matter, sir. Serial number 1, Pradeep Naik, A.V. Arvind.
We will start. We'll start now, and then at 4 o'clock, I intend to resume the single bench at 4 after the division bench. Division bench, we will most probably end it at 4. So we'll start and continue.
The company matter, my lord.
It will not reach. We will accommodate. At the end of it, I'll ask the court officer to fix a date. We'll see. No doubt.
Next week at least, my lord. 2000.
Let us see. We'll try. We'll try. We'll try.
The permanent establishment law will come into effect when the that is chargeable under the rate law business.
Lord, Mr. Arvind is not audible. Can he speak into the mic?
Yes, yes.
The previous paragraph. The previous paragraph which I provided deals with the permanent establishment. The permanent establishment also will be required if there is taxable under the business.
Just 1 minute. ಅದು ಇಟ್ರೆ ಇನ್ನೂ ಸರಿ ಕೇಳಿಸಿ. ಇದು ಒಂದು ಇದು ಬುಕ್ ಮೇಲೆ ಓದಿಸೋದು ಇಟ್ಟಾಗ ಇನ್ನೂ ನೋಡೋದು ಕೆಳಗಡೆ ಬುಕ್ ಇಟ್ಟು ನೋಡೋಣ. Yes.
But in that context, the Honorable Delhi High Court considered how he, in the previous paragraph, 36, the secretary judgment. Now, para 37, the aspect of reimbursement also has been considered, which would be relevant for this case. Let's kindly turn to page number 115, para number 37. By compilation of judgments.
Yes.
This brings the court to the next issue concerning reimbursement and the doctrine of diversion of income by overriding creditor. This court notices that a case with almost identical circumstances in zone also came up.
Just 1 minute. Yes.
This court notices that a case with almost identical circumstances in the case of AT and S India also came up before AR. There an agreement between ATS India and its parent, ATS Austria, was entered into by which AT Austria undertook to assign or cause its subsidiaries to assign its qualified employees to ATS India. These individuals work for ATS India and receive compensation substantially similar to what they would have received as employees of ATS Austria. They were engaged by ATS India on a full-time basis. The question before AR was identical to this case. Whether pursuant to the secondment agreement entered into by the applicant with AT Austria, the payment to be made by the applicant to AT Austria towards reimbursement of salary cost incurred by AT Austria in respect of the seconded personnel
would be subject to withholding of tax under section 195 of the Act in view of the fact that one, the payments are only in the nature of reimbursement of actual expenditure by ATS Austria. Two, ATS Austria is not engaged in the business of providing technical services in ordinary course of business. Three, ATS Austria is not charging the applicant any separate fee for secondment. And four, the seconded personnel work under the direct control and supervision of the applicant. The holding that the application under section 195 will be triggered, the AR held as follows. From the above analysis of both the agreements, it is clear that pursuant to the obligation under the FCA, the AT Austria has offered the services of technical experts to the applicant on debtor's request, and the terms and conditions for providing services of technical experts are contained in the secondment agreement, which we have referred to above in great detail. Though the term reimbursement is used in agreements, the nature of payments under the secondment agreement has to satisfy the characteristics of reimbursement, and that the term reimbursement is the agreement will not be determinative of the nature of payments. The term reimbursement is not technical word or a word of article. In Oxford English Dictionary, to reimburse means to repay a person who has spent or lost money. Accordingly, reimbursement means to make good the amount spent or lost. However, under the secondment agreement, the applicant is required to compensate AT Austria for all costs directly and indirectly arising from the secondment of personnel, and that the compensation is not limited to salary, bonus, benefit, personal travel, etc. Though salary, bonus, etc. amounts referred to in paragraph 4.2 of the secondment agreement and form part of compensation. The premise of question that payments are only in the nature of reimbursement of actual expenditure incurred by AT Austria is not tenable for the reasons more than one. First, it is not
just
by
pause here for a moment. Now, just go to 195 for a minute.
Page 1096.
1096.
All the provisions are in my compilation also, if your lordships find it convenient to mark at page 17 of my compilation, my lord.
Page 17.
Yes, my lord.
Now, under 195, by fiction, under 195.1, we say any person responsible for paying to a non-resident any other sum chargeable under the provisions of this Act. So now the question is whether the payment by the petitioner to Walmart is a sum chargeable under the provisions of this Act. Now they claim it is a reimbursement. Now, if this cost, if it is a cost, now whether this cost is a sum chargeable under the provisions of this Act, are we not looking at it like that?
No, my full submission is what that is what the Honorable Delhi High Court has also held statement. Here, making a heading that reimbursement is not a determinative. They offered not.
No, let us let me clarify. Now, suppose there are two entities in India. Let's assume that there is an entity in Bangalore that is and an entity in Delhi under the domestic law. Now there is some arrangement between the entity in Bangalore and entity in Delhi, similar to this secondment agreement, and some employees are taken to the Bangalore establishment, and they do some work for the Bangalore establishment. For whatever reason, under the agreement, the Delhi establishment pays the salary to the Bangalore employees. and payment is made by the Bangalore establishment with respect to whatever the Delhi establishment has paid as salaries to those employees. Now, this payment by the Bangalore establishment under the domestic law, is it would it be open for deduction as an expenditure, or would it be treated as an income and hence TDS is to be deducted?
So far as that may or may not have an element of not the taxable income.
Correct.
Not the first instance, not whatever the payments are being made. Not the purpose of payment not has to be seen. Purpose is not for deputing not a technical person there. That is the first step. Not there, not the associate is canvassing the second step. I am on the first step. Why did you depute it? They want a technical person, you deputed it. But for that, they have to quantify the cost. Not cost, not the consideration of the rendering of those services. Cost is not equivalent, the consideration is equivalent to the cost. Because it is equivalent to the cost, it will not take away the character of income. So far as the recipient is concerned, because if 100 rupees is received, paid by the Bangalore company to Delhi company, it will be subjected to TDS. If equally 100 rupees has been incurred by the Delhi High Court, Delhi company, it gets squared off there. But the income is declared, they will consider expenditure there, it gets squared off.
So let me understand. So your argument is that whatever it is described as, including as reimbursement of cost, in effect, it amounts to payment for a technical service, in effect. So in that sense, question of treating it as a mere reimbursement doesn't arise. That is your argument.
That is my argument. What they are trying one more aspect.
Yes.
Netting out. Once you net it out, they have incurred 100 rupees, I have paid 100 rupees, nothing is left in their hand. But for that, the Honorable Supreme Court has clearly had to point out that chargeability to TDS is on the gross, not on the net. That's why Malad has submitted. If they want to say that out of 100 rupees, 99 is not taxable, only 1 rupee, then they can go for proportionate under 195. Here they are saying 100 rupees I have paid, 100 rupees they have incurred, nothing is taxable here, but then 192. Some keep on repeatedly telling but instead of the manner of payment, the purpose of payment has to be seen. And I pointed out from the master service agreement itself. If the Walmart has to send some personnel, what type of personnel or expertise the Flipkart was expecting? They could have sent some requisition saying that you send 10 people or 5 people with this qualification. But otherwise, how the Walmart will take a decision? That is not before your lordships or before the EU.
Yes. Now continue.
This I think the remaining one whatever the lordships query and what I was trying to persuade gives an answer. But in my comparison.
Yes.
Because for that, the Delhi High Court at the advance takes a view. It is in the nature of technical services. Because of their closer connection, they may charge equal to the cost. That will not take away the character of chargeable income.
So the other way of looking at your argument is, even if it is contended to be a reimbursement, the test is whether it amounts to a fee for technical services, which according to you is the case.
Ultimately, once it is for the purpose of fee for technical services, whether it remains as a profit, all it completely 100% squares up, or even the Walmart suffers a loss. While you making a payment, you have to see the purpose. How much is taxable? That's what the Honorable
would your lordship
as well as the AP Transmission Corporation has had. But you cannot split up the gross income and say what is the income, net income in that. That has been reiterated. I'll just take your lordship on that.
My lord, would your lordships permit me one small interjection,
Yes.
my lord?
Yes.
One small interjection, my lord. My lord, this whole question of whether or not a reimbursement can be fee for technical services was not decided by the Supreme Court by the time Centrica was decided. But if your lordship sees AP Molar, which I have cited to your lordships, that is a 2017 judgment where the very issue, whether a cost sharing arrangement can be regarded as fee for technical services, was brought up. And Supreme Court, after noticing the nature of the payment, that it is only cost to cost and cost sharing, said it can never be fee for technical services because it is reimbursement. Question of gross and net and all this doesn't arise. If it is reimbursement, it is reimbursement.
Let us see. We'll come back.
Yes, yes, I'll explain that in my rejoinder. But
Yes.
That 116, that underlined portion,
Yes.
in the middle of the paragraph.
Yes.
Maybe little 4 lines above, my lord, for continuous.
Yes.
The term reimbursement is not a technical word or a word of article in Oxford English Dictionary. To reimburse means to repay a person who has spent or lost money, and accordingly reimburse means a make good the amount spent or lost. However, in the secondment agreement, the applicant is required to compensate AT Austria for all costs directly or indirectly arising from the secondment of the personnel, and that the compensation is not limited to salary, bonus, benefit, personal travel, etc. Those salary, bonus, etc. and the amounts referred to in paragraph 4.2 of the secondment agreement form part of compensation. The premise of the question that the payments are only in the nature of reimbursement of actual expenditure incurred by AT Austria is not tenable for the reasons more than one. But first, it is not supported by any evidence as no material except the debit notes of salaries of seconded personnel is placed before us to show that actual expenditure was incurred by AT Austria and what is being claimed as a reimbursement. In this case, also same thing, no such exercise. Secondly, assuming for the sake of argument that the debit notes represent the quantum of compensation as the actual expenditure, it would make no difference as the same is payable to AT Austria under the secondment agreement for services provided by it. It would therefore be not only unrealistic but also contrary to the terms of the agreement to treat payments under the said agreement as mere reimbursement of salaries of the seconded employees who are said to be the employees of the applicant. To show that the real employer of the employees is applicant and not the AT Austria, Mr. So-and-so invited our attention to various employment agreements entered into between the applicant and the seconded employees, and also the certificate of deduction of tax at source on their global salary. All the employment agreements are similarly worded. We have carefully gone through the employment agreement between the applicant and so on so. The duration of the agreement is from 1st September 2005 till 30th August 2008. In Article 3, there are salary of the employee is noted as the remuneration, perquisites and other entitlements as detailed in Appendix A. However, Appendix A does not specify any amount. All that it says is that the salary will be as fixed and agreed between the employee and the company from time to time, and that such salary will be paid either in India or outside India. But the total salary shall not exceed the salary fixed as above, but no fixed salary is mentioned in the employment agreement. Other perquisites and entitlements are travel expenses, transport, boarding, lodging, and annual leave of 30 days per year, and the home leave which the employee will be entitled to once. The applicant shall have to organize an economic class return if flight tickets to go on home leave. The employment agreement also provides that the employees will be responsible for meeting all requirements under the Indian tax laws, including the tax compliance and filing of returns, and the applicant is authorized to deduct taxes from the compensation and benefits payable. The mere fact that CIOB and the secondment agreement raises the payment made from CIOB to overseas entities as reimbursement cannot be determinative. Neither is the fact that the overseas does not charge the markup over and above the cost of maintaining the secondary relevant itself, since the absence to markup subject to an independent transfer pricing exercise cannot negate the nature of the transaction. It would lead to an absurd conclusion if all else constant, The fact that no payment is demanded negates accrual of income to the overseas entity. Instead, the various factors concerning the determination of the real employment link continue to operate, and the consequent finding that the provisions of the employees to provision of employees to CIOP was the provision of services to CIOP by the overseas entities triggers the DPNA. The nomenclature or lesser than expected amount charged for such services cannot change the nature of the services. Indeed, once it is established, as in this case, that there was a provision of services, the payment made may indeed be payment for services which may be deducted in accordance with law or reimbursement for cost incurred. This, however, cannot be used to claim that the entire amount is in the nature of reimbursement for which the tax liability is not triggered in the first case. This would mean that in any circumstances where services are provided between, this is important. This would mean that in any circumstances where services are provided between related parties, the demand of only as much money as has been spent in providing the service would remove the tax liability altogether. This is clearly an incorrect reasoning that conflates liability to tax with subsequent deduction that may be claimed. So far as the decision of refunds, this is what para 38 was submitted. The purpose or nature of services and the purpose of payment has to be seen, not the manner of quantifying the consideration. Merely because the quantification of consideration for rendering services is equal to the cost, it will not take away the character of the purpose of payment.
Yes.
So far as the decision of the fund goes, the judgment notes the judgment notes the distinction between stewardship activities of the employee and reputation, which has been highlighted in Morgan Stanley. The division bench in refund highlighted that the nature of activity undertaken by the employee is determinative of whether it constitutes a service. In the present case, the overseas entities outsource their back office support function like rent collections, consumer billing, month jobs to third-party vendors in India. The seconded employees in the present case oversees quality control of the work of such vendors. This work cannot be characterized as a stewardship. What could have been left to CIOP to do is in fact being done through the seconded employees whose expertise and training lends quality and content to the Indian entity. Therefore, it is held that the real employer of these seconded employees continues to be the overseas entity concerned. The final issue concerned is the diversion of income by overriding creditor. Here, CIOP argues that the payments made to overseas entity is not income that accrues to overseas entity, but rather money that is obligated to pass on to the secondaries. In other words, this money is overridden by the obligation to pay the secondaries, and thus is not income. This is insubstantial for two reasons. One, in view of the above finding that the payment is not in the nature of reimbursement, but rather payment for services rendered. The employment relationship between the overseas entities and the CIOP from which the former's independent obligation to pay the secondaries arises continues to hold. No obligation to use money arising from the payment by the CPIO to pay the secondaries arises. The overseas entity's obligation to pay the secondaries arises under a separate agreement based on independent conditions in relation to CIOP's obligation to pay the overseas entity. Assuming the agreement between CIOP and the overseas entity envisages the separate payment for the provision of services are not styled as reimbursement, no argument would be made that such payment is affected by the doctrine of diversion of income by overriding creditor. If that be the case, then as held above, the fact that the payment under the second agreement is styled as reimbursement and limited on the facts to that without any additional charge for the services cannot be hit with the doctrine either. The money paid to CIOP to overseas entity accrues to the overseas entity, which may or may not apply the payment to the secondary based on its contractual relationship with them. This at very least is independent of relationship and payment between CIOP and overseas entity. Accordingly, for the above reason, this court holds that this restriction is liable to dismiss and the rulings also stands. But also, the Delhi High Court and against this, SMT was filed. That's what candidate over the 121. But SMT has been
there are two issues that will require to be answered. One is whether it's a fee for technical service. One. The point of reimbursement is to be addressed separately. Now let's assume that it is not fee for technical service. Let's assume. And you are just making some payment which you claim as cost. Even in that, suppose it is not a fee for technical service, and still a payment is being made, and then there is a markup, let's assume. Then that one will not be a reimbursement, and still you'll have to pay on that also. Now, this question of reimbursement and fee for technical services will have to be dealt with independent of each other. We can't overlap it as has been done.
But that may have fit into other articles.
Correct.
They not fall under another article.
Correct. Correct.
So that is an independent one. If it is paid without any purpose and that has to be paid, but it has to be seen whether it is in the nature of
Correct. Correct.
different articles.
So reimbursement and fee for technical services are independent. If there is a fee for technical service, question of entering into the question of reimbursement will not arise. But if it is not fee for technical service, let us assume, then whether that reimbursement is actual reimbursement or otherwise is a matter to be independently looked into. Yes.
I was submitting that it should be on the grass.
Just 1 minute. Yes.
But the main contention now is it is equal to the cost incurred. It is on cost to cost basis. There is no element of income in that. What is the element of income not in that? That did not be not being free to or not did not be arisen. What has to be seen is if the payment nature of payment made is taxable. But how much of the amount out of that payment is immaterial so far as 195 is concerned? Now that if not kindly permit me to point out 2 or 3 judgments. This on reimbursement of the proposition that the payment need not be over and above what need not is not on the net. It should be on the gross income. What they are claiming is they have incurred 100 rupees. I have been invoiced 100 rupees. I am paying it. There is no element of income in that at all. But as referred to with the 100 Delhi High Court, nothing is before you are to show that the 100 rupees is spent with the Walmart. They are sending an invoice. How much of the income they have, their expenditure income. That is second aspect. Before that, the first aspect is as I was saying, nature of income, and the TDS should be on the gross income. That perhaps kindly turn to in his reference compilation, just the para I have read it, just in this context, find a few lines page number 70.
Page number
70 in the reference compilation of judgments.
Transmission cost.
That para 9 page 70.
Tara?
The fourth line in that, whether payment of sum to non-resident. Whether payment of sum to non-resident is chargeable to tax under the provisions of the Act or not. That sum may be income or income hidden or otherwise embedded therein. If so, tax is required to be deducted on the said sum. What would be the income is to be computed on the basis of various provisions of that, including provisions for computing of the business income if the payment is a trade receipt. However, what is to be deducted is income tax payable thereon at the rates in force. Under that, total income for the previous year would become chargeable to tax under section 4, subsection 2 of 4. Inter alia provides that in respect of income chargeable under sections 1, income tax shall be deducted at source where it is so deductible under any provisions of that. If the sum that is to be paid to the non-resident is chargeable to tax, tax is required to be deducted. The sum which is to be paid may be income out of different heads of income provided under 14. That is to say, income from salaries, house property, profit and gains and profession and capital gains, and income from other sources. But this is important. The scheme of tax deduction at source applies not only to the amount paid which only bears income character, such as salaries, dividend, interest of securities, etc., but also to gross sums, the whole of which may not be income or profit of the recipient, such as payment to subcontractors and subcontractors and the payments of insurance commission. It has been contended that the sum which may be required to be paid to the non-resident will only be a trading receipt and may contain a fraction of sum as taxable income. It is true that in some cases a trading receipt may contain a fraction of sum as taxable income, but in other cases, as interest on so transfer of rights of parent goodwill so and so, machinery and other transactions, it may contain large sums of taxable income under the provisions of tax. Whatever may be the position, if the income is sum of as taxable income, whatever may be the position, if the income is from profits and gains of business, it will be computed under the Act as provided at the time of regular assessment. The purpose of subsection 1 of 92 is to see that the sum is chargeable under section 4 of the Act for deviant collection of income tax. The payee should deduct the income tax thereon at the rates it was if the amount is paid to the non-resident. The said provision is for tentative deduction of income tax thereon subject to regular assessment and deduction of income tax. The rights of the parties are not in any manner negotiable. Further, the rights of the payee and recipient of fully safeguarded so and so under section 195, 2, 3, and 197. Only thing which is required to be done by them is to file an application for determination and of that. Now, the similar finding that has been held by the Honorable Supreme Court. My compilation. LLB. Just drive on the very same. When the deduction is on the net, it is on the gross. But page number 41 in my compilation.
Then in the nature of payment will have to be ascertained by the officer as to whether that payment, whether you say, let's assume you say even gross. Even that gross, either in entirety or a part, must be chargeable under the provisions of the Act. That question he has to answer.
My report submission, what from the first submission, which I opened is manner of quantification of a consideration for the services that is a secondary. You just see what is the purpose you make a payment. That will determine whether the payment is for services or not. What the assessee says is, to some extent, is not disputing that the payments are in the nature of people technical services.
No,
but the quantification is equal to the cost, it is a reimbursement. That has been negative by the Honorable Delhi High Court. To hold that is not determinative. You please see the purpose of payment.
Correct, but according to me, even the Delhi High Court, the concept of reimbursement is different from fee for technical services. That's my prima facie opinion. Now, suppose you come to a conclusion, it's fee for technical services. You don't have to enter into any other question at all. Suppose you determine it, there ends it. Suppose you were to say it is not fee for technical services. Still, according to me, if he contends it to be reimbursement on cost basis, the inquiry by the assessing officer is actually whether it's a reimbursement, in the sense the whole of it is a reimbursement, or a part of it, as it is pointed out, is only it's only a gross sum, out of which some may be cost, some may be otherwise. That fact, that determination must be made by the assessing authority, which will lead to the answer that it is a sum chargeable under the provisions of
I may be permitted, my lord, to make this submission. But what I was trying to submit, my lord, is that if fee for technical services are rendered,
yes,
but amount, my lord, is paid, my lord, equal to the cost incurred by, my lord, the foreign country.
that would be of no relevance.
No,
if it is,
what has to be seen?
No, if it is fee for technical services, it would stop there.
Please, my lord, that's what, my lord, I am submitting.
That I am with you on that. I am with you on that.
That is, my lord, they are on the second aspect of quantification of consideration. But what I am submitting, my lord, what is to be seen?
No, correct.
Is purpose of payment.
Correct. Now that's why I'm saying. Now suppose it's a fee for technical service, whether it is X amount or Y amount, according to me,
entire amount is
ipso facto, prima facie. This is my impression, subject to further, that if it is a fee for technical service, whatever it is, then it comes within the chargeability.
Please. That's why, my lord, I submitted. As per, my lord, the definition of FTS, not under the DT and of the Act itself, which was referred to in Centrica itself. It's a provision of not personal of technical or other personal. Not to fall within that. For that, whether they are of the technical person or what nature of other personal, the requisition made by Flipkart to Walmart has to be placed before him also. Otherwise, the agreement itself says, the master agreement says, if other subsidiaries make a request, Walmart will send people. But how Walmart will determine what nature of personnel is required to Walmart?
But let us see what they'll answer.
But on the gross and net, just to
yes.
Put on that, my compilation at page 41.
Yes.
But at page 54, current 21. That's not just notice. First line, at the outset, we wish to clarify.
Para?
21.
Yes. Yes.
First line, at the outset, we wish to clarify that our judgment is confined to the question of deductibility of that from the service. Not though they say it is only relevant to section 191. Not whatever the principles of law laid down in the GP transmission corporation, which I pointed out to us, that's pointed that has been reiterated. But about the fifth line, the sum which is to be paid. The sum which is to be paid may be income out of different heads of income mentioned in section 14, that we should say income from salaries, income from house property, profits and gains of business, capital gains, and income from other sources. The scheme of TDS provisions applies not only to the amount paid, which bears the character of income, such as salaries, dividends, interest on securities, etc., but the said provisions also apply to the gross sum, the whole of which may not be income or profits in the hands of the recipient, such as payments to contractors and subcontractors. The purpose of TDS provisions in Chapter 17B is to see that the sum is chargeable under the Section 4 of 4 for levy and collection of income tax. The payer should deduct tax thereon at the rates in force. The amount is paid to the non-residents. But the same principle has been breached. Only for that purpose I pointed out for this.
But in the transmission corporation, they make one observation that element of income must be there, at least embedded in that payment. Suppose now here you are saying that you look into the gross sum that is paid, even if it is not in the nature of income prima facie, you must. It's not open to say you must not deduct.
That is what I submitted. That exercise, whether it is a zero.
Correct.
In deduction.
Yes.
Even if I make a deduction on the 100 rupees what I am paying, because 100 rupees has been incurred by Walmart. If you subject Walmart to tax, because 100 rupees they will offer it as an income, they will apply 100 rupees as an expenditure, so taxable income will be zero. For that, 197 is the exercise. There, the assessing officer 197 would have been there. You would have insisted the accounts of the recipient be placed. Otherwise, impacts as been held is not my argument. But what the Honorable Delhi High Court has expressed. Here, a debit is a self-evidence document. It is not substantiated. But tomorrow, they may say 100 rupees is charged as an invoice, as not being paid as a salary. Tomorrow, we cannot rule out the possibility of 50 rupees being paid as a salary there. Because invoice will not finally determine that is the nature of income which is being paid. Even the Honorable Delhi goes to further extent, saying that on the entire invoice value, TDS will not under 192 even if it is made. That is a must. Actual expenditure in the hands of the recipient will not be incurred. That is a must.
In his inquiry, I'm just throwing it open, just the assessing officers when they're doing this inquiry. One, of course, this is a case where he has gone ahead without entering into the question of composite payment. So we leave it at that. But otherwise, while even under 195.2 or 197, he must call upon them to furnish whatever other documents he requires so that he could come to the finding whether it is deductible or not, even if it means it is prima facie. No doubt, the final liability on the recipient is a matter to be discussed at the appropriate stage after inquiry. Nevertheless, even at yes.
Assessee himself, because he has filed an application, the assessee should have placed in that agreement. This is the nature of person I made a requisition. This is the nature of this qualification. For this purpose, Walmart has sent the bill. But in the absence of the assessee will not voluntarily produce those documents which are crucial. The assessing officer also no doubt should have asked for that. But that could have in fact not glitched it.
We will continue at 4. Meanwhile, find out what was the material placed before the assessing, before the authority.
I will try to secure the file itself for the impossible.
Yes, Jeevan, that other will continue at 4, tentatively at 4. So same order as
But item 8 in the
use the mic so that just 1 minute. File put.
The petitioner is from opinion. Cause of action has arisen by virtue of my lord, some notices being sent to my lord petitioner by 2 entities. Expression could be indicated here.
So that part of the cause of action.
Because of the notification, my lord, Union of India has
They have challenged.
one modification.
Finally, the judgment.
Consequence of that demand is
Correct. So that part of cause of action, if it accrues here, still that would suffice.
next D is challenged, my lord.
Yes.
Therefore, all other matters are pending in this court.
Yes, yes. So the same interim order as the apex court order. Apex court order.
Yes, but one thing is subsequently apex court said approach the high courts.
Yes, yes.
So same order may kindly be passed in this matter. Page 210.
So the order that we have said is
210.
Payment of GST for grant of mining lease royalty by the petitioner shall remain stayed.
Yes.
similar orders are also passed in my lord earlier service tax regime. Still pending.
Statement of objections to be filed. List the matter after filing of statement of objections. Yes, yes.
Interim order is passed.
Yes, yes.
Yesterday that RP will have forgot. Sorry.
With your lordship's kind permission, my lord.
Yes.
Serial number 1,
Yes.
Vaisala matter. My lord,
Yes.
OLR 5 has to be considered where we made an application to only implead ourselves before the trial court. This matter can still go on, madam, my lord, that only impleading we want the permission, which is the matter between this honorable court and the official liquidator, my lord. We are only seeking a permission to implead ourselves, my lord. We filed the detailed OLR 5. Last occasion, your lordship heard me where the trial court has observed that you did not seek the permission of the honorable court to implead yourself. So we will not accept your impleading application. So we made an application as stated by the council also that she has to make an independent application. We have now made an OLR independently to implead ourselves, which this honorable court can permit us because we are going before the trial court. Once our impleading is permitted by the trial court, we'll be contesting.
OLR number?
My lord.
OLR?
OLR 5, my lord. OLR 5 of 2022, my lord. Filed on 11th January, my lord. I produced the judgment of this honorable, the trial court also. Your lordship may kindly see at page 71. The relevant paragraph, internal page 14. If your lordship gets page 71, internal page 14. Your lordship gets, my lord?
Yes.
the line starts second line. He has not produced any document to show that he has filed application, that is official liquidator, as per the directions of the winding up court or central government. He has filed the present application independently. Under these facts and circumstances, and also on the ground that there are no sufficient document to show that the present suit property is a property of Hoysala Development Company Private, I do not find any merits. The applicant is not proper and necessary party. So he's telling that not produced any document, that he has filed an application as per the direction of the winding up court. So further also they say in the other paragraph also that if your lordship may come the previous page 70, internal page 13, para 15. Para 15.
Yes.
As it is rightly contended by the applicant, he is the officer of the Honorable High Court of Karnataka, but he has to perform his duties according to the instructions given by the Honorable High Court of Karnataka. Since official liquidator is appointed by the central government, he has to perform his duties as provided under 360 of the Companies Act, as central government may prescribe. Further, he can also exercise powers as provided under 290 of the Companies, apart from the duties prescribed by the central government. Though under section 290 of the Companies Act, liquidator has got the power to institute or defend any suit, prosecution, etc. in the name or on behalf of the company. He shall exercise the powers under 290 of that, subject to overall control of the tribunal, and he shall perform the duties as the tribunal may specify in this behalf. But the applicant has not filed the present application as per the direction of the central government or winding up court of the tribunal or the tribunal. So they are very clear.
Correct. What I'll do,
Yes.
we'll on next time we will not pass it over. It will be in the same, and in the first round itself, I'll consider and pass the order insofar as the OLR is concerned.
Please, madam. Please, madam.
Learned counsel for the official liquidator would point out that OLR, that which is this OLR?
OLR 5 of 2022, my lord.
OLR 5
Five,
of
my lord.
2022. That as regards OLR 5 of 22, orders will have to be passed without waiting for disposal of the CA 819 of 2003 and other applications. Taking note of the same, it is clarified that the said OLR will be taken up for consideration on the next date. List the matter on 24th. On that day, you make a submission.
Please,
We'll dispose of the OLR, then the rest will fix a date.
Yes, my lord. Please, my lord. Oblige me.
My lords, may I make a submission, my lords? My lords, serial number 13 in list 3, my lords, due to some network.
Can't hear you. Can't hear you.
Serial number 13, my lords, in list 3. Due to some network issue, I was unable to hear, my lords. I appear for responding to in IA 3 of 15, and Wakalat has already been filed, my lords, in this matter. But my lords had directed me to file Wakalat. I do not appear in IA 1 of 15. I'm respondent number 2 in 3 of 15, my lords.
Step for up to 1 3.
You represented R2, isn't it?
R2 in IA 3 of 15, my lords.
So notice for R2 in IA 1 of 15 and 5 of 15 is different. They released the same statement.
Your my lords. My lord, am I audible now?
ಹೇಳಿ.
Court officer?
Take a note. Take a note.
It's taken.
Your submission, take a note.
Okay, thank you.
Court officer. Court officer.
ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ.
ನಾನು ಅದು ಡೇಟ್ ಕೇಳಿಸ್ಕೊಂಡಿದ್ದೀನಿ 819 ಯಾವ ಡೇಟ್ ಹೇಳಿದ್ರು ಫಸ್ಟ್ ಮ್ಯಾಟರ್
24th.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
Court officer. Court officer.
ಹೇಳಿ ಮೇಡಮ್ ಹೇಳಿ.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಲಿಸ್ಟ್ 3 ನೆಟ್ವರ್ಕ್ ಇಶ್ಯೂ ಇತ್ತು, ನಂಗೆ ಕೇಳಿಸಲಿಲ್ಲ. ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ ನಾನು. ನಾವು ರೆಸ್ಪಾಂಡಿಂಗ್ IA 3
ಆಗಿದೆ.
ಓಕೆ.